Burlington School Committee versus Massachusetts Department of Education. The case study that I will examine is Burlington School Committee versus Massachusetts Department of Education, where the Supreme Court affirmed that if public schools cannot offer the needed services in the student's IEP, then the parent can elect to enroll their affected student in an alternative school and still be eligible for reimbursement under the IDEA's free appropriate public education definition. And parents of IDEA recognized students cannot arbitrarily supplant their students into private institutions without review procedures or may be personally liable for the tuition. And the Supreme Court also cautioned against parents who unilaterally change their child's placement during the pendency of review proceedings. Here's a little background on the case. It first started with Michael Panico, a third grader at Memorial School in the town of Burlington, Massachusetts, and he was receiving special education services for his specific learning disabilities. While having these specific learning disabilities, the school and Mr. Panico, his father, both agreed that Michael was above average to superior intelligence. Despite this assessment, he was still slipping some. His IEP required services that could not be delivered by the school, and he was recommended placement in another school, the Pine Glen School. Contentions first arose in this proposed IEP because of the placement and the source of his condition, where the father argued that the condition of his son Michael was neurological. The school district insisted that it was emotional. In 1979, Mr. Panico sought review with the Massachusetts Department of Education's Bureau of Special Education Appeals, BSEA, on this IEP, and in the fall of 1970, the BSEA deemed this IEP placement at Pine Glen School as inappropriate and that the town should reimburse the Panicos for the cost of tuition. Again, during this time, Mr. Panico had his son evaluated by specialists who had recommended placement at the private institution of the Carroll School as an appropriate school for Michael. And Michael was enrolled in this school, assumedly under some endorsement from the town of Burlington. The town then rejected this review and sought judicial review in U.S. District Court, where the court extended a summary judgment against Mr. Panico and the State Department of Education for lack of a preponderance of evidence. After this judgment, the town then rejected to pay for Mr. Panico's educational expenses. The State Department of Education then threatened to withhold state-supplied educational funds. Then, the town of Burlington agreed to pay for the 1980 through 1981 tuition, but not the 1979 through 1980 school year. When going to the appellate court decided that they needed to remand the case back to the district court and told the district court to examine if Mr. Panico violated the IEP by enrolling in a private institution. The school district overturned the BSEA review decision and stated that the placement at the Pine Glen school was appropriate, and the case was appealed a second time by Mr. Panico. In this second appellate decision, the court remanded the case again and instructed the district court to examine, and I paraphrase, that Mr. Panico's son's placement was under the instruction of the BSEA. In protest, the town filed a writ of certiorari for review, and the Supreme Court accepted, but only wished to look at the following 2 points. The first point was whether the potential relief available under Chapter 3 bars such reimbursements to parents who reject a proposed IEP and a placement of a child in private school without the consent of local authority. The court wanted to define the free and appropriate public education in this particular circumstance under Title 20 U.S. Code subsection 1401, Chapter 18. Then the role of an IEP stated in Title 20 U.S. Code subsection 1401, Chapter 19. And finally, the role of an administrative review as per Title 20 U.S. Code subsection the role of an IEP stated in Title 20 U.S. Code subsection 1401, Chapter 19. And finally, the role of an administrative review as per Title 20 U.S. Code subsection 1415. Under the review of the IDEA and the intentions of the FAP, the Act authorizes reimbursements for appropriate education outside the public schools systems. The Supreme Court also questioned whether students should have to wait weeks versus years for administrative IEP reviews and how that can affect the child, and the parents are forced to sustain inappropriate education or risk not being awarded for appropriate education. So the courts allowed this reimbursement of private institutions when the IEP suggests that a private institution is appropriate, but also cautioned that parents cannot change the placement without IEP approval or risk forfeiture of reimbursement.